Hi, I'm attorney Reed Bloodworth, the managing partner of Bloodworth Law in Orlando, Florida. We handle employment litigation across the state. Today, I'll address whether an employer can enforce a non-compete agreement. If you come to Bloodworth Law after there's a problem, you're already in an unfortunate position. A non-compete agreement is only as good as the attorney that drafted it. Let's look at the key elements involved in a valid non-compete. To answer the question, is it enforceable? There are really two things we look for. One, a non-compete must be reasonable. Reasonable in time, geography, and scope. Two, a non-compete must be justified by a legitimate business interest. Reasonable in time is generally considered to be 6 months to 2 years that a non-compete may last. Anything over this length of time may not be considered reasonable. Reasonable in geography. A Florida non-compete is limited to where you do business. If you don't do business in New York, you're going to have a difficult time enforcing your non-compete against someone in New York. Finally, there has to be the protection of a legitimate business interest for the employer. Merely wanting someone not to compete with you is not a legitimate business interest. Here are the legitimate business interests directly from Florida statute. They include a trade secret, valuable confidential information, substantial relationships with clients, extraordinary and specialized training, customer goodwill, an ongoing business or professional practice by way of trade name or trademark, a specific geographic location, and specific marketing or trade area. These are the legitimate business interests, the reasonable lengths of time, geography, and scope that are needed to enforce a non-compete in Florida. If you want to know if you can enforce a non-compete and need to know the next steps, give me a call. Let's talk about how Bloodworth Law can help you or your business.